Set.
So welcome everybody to our first 2021 what are now monthly chats. We appreciate your joining us tonight. We know how busy and stretched everybody is. I'm here tonight with Liza Hirsch, another MAC attorney, and also from MAC is Lilia Malekshi and Joanne Pino, who will be helping out. Joanne is also kindly celebrating her 60th birthday with us tonight on this Zoom chat. So thank you, Joanne. What could be better to celebrate 60 amazing years? We do recognize that this has been a very intense and upsetting last few days with the violence and racist events in Washington, D.C., the growing schisms in our country, and the just obviously very tumultuous times that we're in, on top of entering the 10th month of the pandemic with the surging numbers and so many children and families continuing to struggle to obtain the basic educational services they need. We know some students are receiving in person, at least on a hybrid basis. Many others are continuing, increasing numbers that are totally remote, that is often not accessible. And we just really recognize that it can be nothing harder than watching when your children cannot obtain the services that are just so vital to their development. We know during the pandemic, there's no perfect solutions until schools fully and safely reopen. There's going to be continued obstacles for many, a long recovery, and we're hoping to provide some advocacy, some tools, and some strategies that can help in these difficult times. We know, and many of you have seen that the state is rolling out pooled testing in the K-12 schools, which we're hoping will increase the pace for safely reopening schools. There's a lot of hope for many slowly with the vaccine rolling out. And tonight we're going to talk about some new state rules and state guidance that we hope will provide some additional advocacy tools for you to use and then help ensure your children can receive equal opportunities in these difficult times. Liza and I are both going to speak. We're going to leave most of the time for the Q&A at the end. And Lilia, a few housekeeping things to go over.
Yeah, thank you everyone for joining us. Welcome back to our regulars and happy birthday to Joanne. So tonight we will be pausing throughout the presentation to take your questions. Please submit your questions at any time using the Q&A button on the bottom of your screen. If you're joining us on Facebook Live, please submit your question as a comment under the live stream. If you see someone else's question that you'd like us to answer, please give it a like. And please keep an eye on the chat box in Zoom and the comment section in Facebook for resources that we'll share throughout the presentation. Thank you.
And also share your own strategies. We know there are a lot of very knowledgeable, experienced parents and advocates who are joining us tonight. So if you have ideas or strategies, advocacy tools that you use that have been effective, please share those with us as well in the chat, right? Is that where they should share their ideas, Lilia?
Great. In the comment section on Facebook and in the Q&A on Zoom.
Great. All right, Liza, should we get started?
Yes, let's get started.
I'm trying to move, there we go. So there are new state regulations that we want to just briefly tell you about that will go into effect on January 19th, which is next week. And these are state regulations specifically defining the minimum, and I want to score the minimum part, amount of what the regs call live instruction that's required for all students during the pandemic. And there's different time frames for students who are full-time remote and for students who are receiving hybrid instruction. So I'm briefly going to go over both of these. Basically, for students who are full-time remote, over a 10-day cycle, the district has to make sure that at least 40 hours of the instruction over the 2 weeks is synchronous instruction, live instruction, not pre-recorded sessions, not packets, but live instruction from educators. And the state and the Board of Ed voted on these regulations after doing a survey of school districts throughout the state to try to based on the survey results, ascertain how much live instruction students were currently receiving. And based on the survey, many of you, 2/3, will be receiving these minimum requirements, but about 1/3 of the districts throughout the state are currently providing less than this minimum amount of live instruction that's required. We know from the chats we've been having over these last many months that this has been a big issue for many, not all, but many children with disabilities who are not able to effectively learn. So through relying so much on pre-recorded sessions or packets that they can't complete independently, or being able to learn social skills and communication skills in instruction that's not live. So we're hoping and expecting that this will be an important tool that will also help to address some of the mental health and social isolation issues that have been impacting many, many children who are so disconnected from their teachers and their peers, to have at least some minimum amount of live interaction and live instruction. In addition to the minimum of 40 hours, it's the live instruction has to be provided each school day. And also every school, each school day, the student has to have some opportunity to interact with the teachers, with the teacher, you know, whether it's through an individual feedback situation or an office hour, but there has to be some live interaction with teachers that's provided. There is a waiver process for states, but for districts applied to for the state if they have a compelling reason that they can't meet this standard. But at least at this point, it doesn't seem that there's been a huge number of districts that have been applying for waivers. Liza, do you have anything to add about this?
Not at this point.
The one thing to also realize in terms of these minimum requirements is that IEPs still have to be fully implemented. So there may be some children who are going to require 100% of their time to have live instruction in order to have their IEPs implemented. These are minimum time requirements for all students, but it's very clear that separate from this requirement, whatever is necessary to fully implement a child's IEP must also be provided. And then very briefly, the requirements in the new state regulations, again, they go into effect next week, are that for students who are in a hybrid situation where they have some days when they're in school receiving live instruction and some days where they're home, then the minimum amount of hours of live synchronous instruction is 35 hours over the 2-week period. And again, all students have to have a chance every day to interact with teachers. And we know from what we've heard from the chat and from our helpline that this is also really important, because we know that for some children in districts that are being educated in a hybrid model, it's been very difficult on the hybrid days because there's been no live interaction or teaching during those days. So we're hoping that these regulations that set the minimum requirements will help to level the playing field, you know, for all kids, but and for kids with disabilities. Anything to add here, Liza? And then lastly, just an important reminder, because we have been hearing that this has become an issue for many families, and we know there's going to be a lot more annual IEP meetings being held in the coming months. So when your IEP team meets, the IEP is supposed to be written reflecting what your child's needs are for instruction and services when based on the schools being fully open. The IEP cannot legally be written based on what limited services are currently available due to the health and safety requirements that are limiting the way schools can educate kids. And we've increasingly been hearing that IEP teams, leaders have been directed probably to say that the IEPs should be written with fewer services. You know, we've heard somebody say, well, you shouldn't include the social skills goals or the social skills groups because we can't provide those with remote instruction. Or we should reflect the limited ability to provide inclusive education right now. So it's the main point, one of the main points we hope you walk away with is that it's really clear, even before COVID, the case law and it's just kind of the basic tenet of special ed law that an IEP has to reflect your child's needs and cannot be based on a limited availability of services, of funding, and of options. It's the letter of the law before COVID, and it's the letter of the law during COVID in our view. So, and if this IEP is reduced in the amount of services because of the limited opportunities to provide services during COVID, then when schools reopen, we're very worried about students going back to fully open schools with IEPs that do not fully reflect their unique needs that result from their disability. And then the recovery will be even harder. And I'm going to turn over to Liza.
Great. So good evening, everyone. I'm going to talk about a new guidance that was issued by the department. It's a guidance on student engagement. And the full title of the guidance is Promoting Student Engagement, Learning, Well-Being, and Safety During Remote and Hybrid Learning. So this guidance applies to students with disabilities, but also all students more broadly. The majority of the guidance document, actually, and Julia, can we go back to the full?
Oh, sorry, I didn't mean to do that.
The majority of the guidance document actually is a compilation of sections from prior guidance documents. So much of the content for this guidance document is actually pulled from a prior guidance on social emotional well-being, for example. And much of the guidance basically is reiterating points that the department has already made in previous guidance. And so these are some of the main points that are reiterated, kind of repeated again in this guidance document. First, and this is something that we've said over and over again, but it's always worth reiterating, the importance of ongoing two-way communication with families in their primary language. Even though the department has been very clear in multiple guidance documents about this, it's still not always happening consistently, that two-way communication is happening on a regular, frequent basis with families. And so that point is again emphasized in this guidance. The guidance also reiterates the importance of providing families with technology support so that students can access remote learning. That's obviously very fundamental and critical. It emphasizes that it's important to set aside time for culture and relationship building between students and teachers and also between students. And then it emphasizes that schools should be focusing on addressing barriers to participation in remote learning. So for example, barriers due to technology, not having the right device, not having adequate internet connection, for example, or just needing technical assistance regarding technology. And then also other kinds of barriers could be student not having adequate space at home. This is particularly applicable to students who may be homeless in congregate care settings or doubled up, where they might not actually have the space to log on to remote learning and have that kind of privacy. And then finally, language access barriers. So again, none of this is new. It appeared in prior guidance documents, but the department reiterated all of these things in this guidance. And Julia, if you would go to the next slide.
Trying. Yeah.
So there are a few things that are new or newer in this guidance. The first is discipline. Discipline was addressed in the comprehensive fall reopening special education guidance, and there was language to the effect of discipline should be used only as a last resort with students with disabilities. And basically this guidance document addresses discipline for students with or without disabilities and takes the same position, which is that the department strongly recommends, this is the language of the guidance, that districts avoid using exclusionary discipline during COVID-19. And the reason for this is because the department recognizes that so many that's all students have missed out on so much in-person learning time. And many students have also been experiencing significant trauma during this time. And so the department recognizes that many behaviors that are going to be arising either in the remote setting or in the in-person setting during this time are going to be connected to the stress, anxiety, and trauma that students have been experiencing. And so excluding students or punishing them is really not going to be the most appropriate or effective way to respond to student behavioral issues. And then particularly if it's a student with a disability and the behaviors are disability related, and the behaviors may be, again, exacerbated due to the stress of COVID, the department recognizes that discipline is not going to be the most appropriate solution. And the guidance emphasizes that schools should be using alternative practices such as conflict resolution, using positive behavioral supports, and restorative practices or restorative justice, just as some examples. Go to the next slide, Julia. The guidance also for the first time, this is the only guidance I'm aware of that addresses this particular issue, which is the filing of child requiring assistance or CRA applications by school districts regarding students who are, I think in this case, what we're dealing with most frequently is CRA applications that might be filed by school districts because a student is habitually truant or kind of chronically absent from school. And so I think educators have had some questions about if a student is kind of continually absent from remote learning, for example, what is the most appropriate way to handle that situation? And the department in this guidance document makes clear that well, at first I should just say a little bit more about what a CRA is. A CRA is a petition that a school district, in this case, it can also be filed by parents for different reasons, but in this context, it's a petition that a school district files in juvenile court regarding a student who's either habitually truant or what's called a habitual school offender. And again, the most relevant form of CRA that we are dealing with now is the CRA filed based on a student who's habitually truant. And oftentimes we're talking about students who might be absent in a remote learning context. So the department in this guidance basically says that it's that CRAs should not be the primary way that school districts address attendance issues, and that districts should explore and document basically all other avenues to support the student and family to overcome barriers to attendance before filing a CRA. So the CRA should not be the go-to for school districts if a student is not attending, remote learning sessions. And the reason the department, I believe, took this position is because, again, there are many, many reasons that students may be absent from remote learning right now, and many reasons which are based upon legitimate barriers to remote learning. So families and students who don't have adequate technology, we see, and probably many of you understand this, that there are many students with disabilities who are really unable to access remote learning or have a very difficult time accessing remote learning and learning through the computer screen. And so they may be absent more because they're just not able to engage or access that type of, that form of instruction. And so the department acknowledges in this guidance that it's really not appropriate to file a CRA petition based on truancy if a student is not attending remote learning due to barriers based on their disability, barriers based on technology, language access, or other reasons. So, and the last thing I'll say about this is that the guidance is very clear. There's a common misconception that a student is going to be able to access more services through the CRA process, through the juvenile court. And that's really a misconception because the juvenile court is not a social service agency, and students are really not able to access any services through the juvenile court. The juvenile court is able to assign a probation officer, for example, but is really not able to provide any services. And so DESE in this guidance actually clarifies that point, makes that very clear, and encourages educators to really try to support families so that students are able to attend and access remote learning rather than using this system. So next slide, Julia. And then finally, filing 51A reports. So as many of you might know, 51A reports are reports that can be filed by educators and other mandated reporters when they have reasonable cause to believe that a student is being abused or neglected. And this guidance document addresses when it's appropriate and not appropriate to file a 51A report in the context of COVID-19 and a lot of remote learning. And what the guidance states is that districts should be exploring and documenting all possible opportunities to support the student and family to overcome barriers to engagement and attendance, and that should be the first thing that school districts are doing, rather than filing 51A reports. So if, for example, a student is not attending remote learning sessions, the district should explore why that might be, try to support the student and the family, explore whether it might be related to a technology issue, whether it might be related to a disability. Again, we've seen a number of cases in which students have a hard time attending remote learning because of their disability. And school districts should work collaboratively with families to support students to attend. And that 51A reports should only be filed after, all of those attempts have been, multiple ongoing attempts have been made to address all access barriers, and when there is reasonable cause to believe that there is abuse or neglect, which is it's a fairly high bar in terms of, when one of these reports should be filed. But really the takeaway here is that the school district should be working, to address barriers, we believe first before resorting to this option. So next slide.
We have a question here. Can you please describe the difference between a CRA and a 51A?
Sure. So a CRA, again, is child requiring assistance, and there are a number of different types of CRAs. The one that I've been talking about is a CRA, which can be filed by a school district on the basis of truancy. And that is an application or a petition which is filed in juvenile court and then is heard by juvenile court. And again, the juvenile court can assign, for example, a probation officer to basically supervise that student to make sure that they're attending school. Also, through the juvenile court process, the Department of Children and Families, or DCF, can become involved. And if there are concerns about abuse or neglect, it is possible for the Department of Children and Families to take custody of that student. But the whole process takes place through the juvenile court, and the CRA application is filed in juvenile court. A 51A is a report which is filed directly with the Department of Children and Families, and it's on the basis of it's if someone who's a mandated reporter, and teachers, educators are mandated reporters. A 51A report must be filed if an educator has or other mandated reporter has a reasonable cause to believe that a student is being abused or neglected. And so really the difference is one gets filed with DCF, the other is an application in juvenile court. Both can result in having DCF involved at some point, but that's the main difference between the two. I think you're muted, Julia.
Liza, should we just open up to questions we have, or do you want to go over briefly what we can do? What do you think?
Yeah, I think that, we can just say briefly here that we encourage you all to contact your school district or file a PRS complaint, a problem resolution system complaint with DESE, Department of Elementary and Secondary Education, if the school is not complying with these new regulations and guidance in this guidance document that we've reviewed tonight, and the, issues we've talked about in the past. If your child is unable to access remote learning, if you believe your child needs in-person learning and is not getting it, or if your child is not receiving needed IEP services, evaluations, or not receiving needed IEPT meetings. So we always encourage you to go to the district first, try to work it out on that level. And if you can't, there are a number of different options, but one option, if you believe there is non-compliance, is to file a PRS complaint with DESE. And we have a link on this page to that complaint form, as well as other kind of conflict resolution options. And now I think we can probably open it up, Julia.
Yeah, great. And then there'll be more of this information and some other resources in the slides that Lilia sends early next week. So I'm going to stop sharing and open it up. Thank you, Liza. That was great.
Yeah, thank you. So our first question is, my child's school is now pushing back on providing additional IEP goal support since the start of the school year, saying his peer group is behind one grade level in reading and writing, so he doesn't need anything more. However, my child has a learning disability that impacts his ability to read and write, and he's behind a grade level for the last 2 years. We had outside independent testing that shows how far he's behind, but the school said it's due to COVID. I'm really frustrated. What can parents do? I know we aren't the only ones getting this story.
Let me make sure, I'm trying to make sure that I understand it. So the district is trying to reduce the goals and the services, saying that, trying to figure out what they're arguing, that it's not because of your child's disability that they're not making their progress. They're trying to say that it's because of COVID. Is that what the question is?
They're saying his peers are behind one grade level, so he doesn't need anything more.
Yeah, that doesn't make sense to me at all legally. It's kind of what we're talking about. It's similar to the other things we've been hearing from our helpline about how there's been attempts at IEP meetings to reduce the goals and the services. So I think it's really the same point as what I would suggest to that family is, and Liza, you made some other thoughts, but the special ed law, federal and state, is the same. The IEP has to include the goals, the objectives, and the services that are necessary to address your child's learning needs that result from, in this case, the learning disability. The fact that other kids are behind because of COVID is really irrelevant to that, because the state curriculum frameworks for what 4th graders or 10th graders or 12th graders are expected to be learning are the same. The fact that kids, and all kids with disabilities need to be receiving the services necessary to help them access the state's curriculum frameworks for the grade that they're in. That has not changed. The fact that all kids may be behind right now really does not change the goals and the services. Liza, do you have anything you want to add to that?
No, I completely agree with that. And I think, you could just say, my understanding is that the IEP should be written based on my child's individual learning needs, not based on the needs or progress of other students. I mean, it's really that simple. So I don't think that that's just legally viable argument that the district is making.
And if this caller, this family wants to, email us or call us, we could give them some of the sites from the laws and the regs that they could use with their school district, if that would be helpful.
Thank you. And I'll post our helpline information in the chat as well if anyone wants to discuss more in depth with our advocates. Our next question is, I have an IEP and a CCS meeting next week. This is a 2-part question. What form, the IEP or an IEP amendment, for example, should be used to document the agreed upon COVID compensatory services? The second part is, can outside providers be contracted to provide COVID compensatory services?
Do you want me to go ahead?
Go for it.
So just to review, CCS, I think that the question made clear are the COVID compensatory services that all students should be having IEP meetings to determine whether or not they need the COVID compensatory services if the child's been unable to, has either not been offered or has been unable to access their IEP services from March up until the date of your IEP meeting is next week. You can look at the compensatory services up to the date of that meeting, and you still may need to have another IEP meeting later on in the spring or next fall if your child continues not to receive all their IEP services. The state has been really clear in their guidance that all students should be having these IEP meetings to determine whether or not they need compensatory services. If they do, the services are not part of the IEP, but they have to write down what amount and type and frequency of services your child needs. It can be included in the N1 form. It can be included in IEP notes. They can include it in any kind of written document, but you have to have in writing what the IEP team agrees to in terms of the compensatory services. But it isn't a part of the IEP in terms of going in the service delivery grid. There's no requirement that the district hire outside consultants or outside contractors to provide the agreed upon compensatory services, but there's nothing to preclude districts from doing that either. You know, many districts before COVID would sometimes contract with ABA providers or speech therapists if they didn't have sufficient numbers. And if it depends on the time of day and when these compensatory services will be provided. So I can't think of anything legally that would require them to hire somebody outside unless they didn't have qualified, but they don't have the sufficient qualified staff, then they have to figure out how to provide the services that are available. So the state's also been clear that districts can use some of the additional federal stimulus money, and they've let them know what funding they can use, because clearly there's going to be some cost associated with providing all the compensatory services that many kids will need. Liza, anything to add?
No, I think that pretty much covered everything I was thinking.
Next question is, can I file a PRS complaint if my child could not access remote learning due to their disability? They require a one-on-one and Zoom lag time makes it impossible for timely error correction.
The short answer is yes. Absolutely. It may well be worth it to first, contact the special ed director. If you've already tried to work with your IEP team or the team leader, it may well be worth first contacting and writing the special ed director or the superintendent to see if they will agree to provide, to address what the barriers are and figure out how to make sure your child can, whatever is needed, I don't know your child's situation, so that they can better access remote learning, or if they need in-person instruction, ways to provide that in-person instruction safely. But if you're not getting the kind of response that enables your child to have access, that's absolutely appropriate for either PRS, the state complaint system, or an appeal or mediation through the Bureau of Special Ed Appeals. Liza, other thoughts?
Yeah, no, I completely agree. I think PRS would be appropriate, and I think that you could cite some of the guidance documents and some of the language that the department has issued regarding the requirement of making sure that students with disabilities are able to access remote learning. So, and we, I think we'll be sending out some links, and on our website we have, links to information on those guidance documents. But I think it would be helpful to reference some of the COVID-19 special education guidances if you were to end up filing a complaint.
Thank you.
Great.
Our next question is, the district says they have limited TAs to support the IEP because of COVID, and staff are assigned to remote classes while my daughter is in school. She is not being supported per the grid on her IEP, but the district says that she's supervised yet not academically supported. Should I insist they hire additional staff?
TA.
Like a teaching assistant, I think.
Paraprofessional, they mean.
Para, I think, yeah.
Yeah. Do you want to go with this one first, Liza?
I guess what I would say is just that the school district has to be implementing your daughter's IEP and all services on your daughter's IEP. The guidance has been clear that the way services are delivered might look different because of COVID-19, and to ensure health and safety during this public health emergency, but all services on your child's IEP must be delivered. And so that would include, if I don't know exactly what your daughter's IEP says, but if she does have a one-to-one aid, for example, or something to that effect, the school district does need to find a way to implement that service. Again, it might look a little bit different because if your daughter's logging on through Zoom, it may be that she has breakout sessions with the aide, or there's some other way that support is happening, but whatever is on the IEP does need to be implemented. And so I would suggest that is what you should be insisting, that your daughter's IEP must be implemented, and go back to your IEP and, quote and cite the language from the IEP itself. With regard to whether additional staff should be hired, I think that's really, it's up to the district, how they provide the services that your daughter is entitled to on her IEP. And if they need to hire additional staff, they need to hire additional staff. But I don't think you necessarily need to get into that level of detail. You can just reference your daughter's IEP and say this needs to be provided.
And I mean, it is true. This is with how hard teachers, administrators, parents every day are working to try to make sure your kids are learning and accessing the services. There are staffing issues, and the state's aware of that, and districts are aware of that. And as Liza said, it doesn't minimize the need to implement your child's IEP and to make sure that they're getting the services that they need. So it gets to what we're talking about again at the beginning. The availability of services should not be the criteria for determining what your child is getting, even right now during COVID. But you can partner with them to figure out ways to creatively think about how to get those supports in there.
Thank you.
And if people have, again, it's a really knowledgeable group that's here tonight. So if you have other ideas or suggestions about how to answer some of these questions, please drop them into the chat or Q&A.
Yeah, thank you. Our next question is, the district is offering 4 days per week in person with Grid C, 3 times 50 reading instruction and 3 times 50 SLP based on high needs for a high school student. The student has opted for full remote since September, given health concerns for the student and the family. The district has stated that if the student attends in person, he will receive his Grid C services. As long as he opts for full remote, the district claims they are not required to provide these services remotely. Therefore, they will be delivered when available. Is this accurate? I see a lot of shaking heads.
No, there should be shaking heads throughout all of the heads that we can't see. That's a really good question. I understand the districts are struggling, and it is very clear that if a family needs to choose for health and other health for the child, health of the family, that the child stays remote. The IP, whether it's calling for a one-to-one aid or whatever other services are in there, still is required to be fully implemented. So that's, again, an issue where if you've already tried to contact your school district, that filing a complaint with the state or going to mediation could be effective. Liza, do you have anything you want to add?
No, I completely agree. Yeah, the answer is no, that's not lawful.
Next question. My child cannot access remote learning due to his disability. The school marks him absent. The school asked me what I thought he needs. This seems to be putting it back on me to develop a plan. Should I expect them to try to take a more active role?
These are great questions. I think the guidance that Liza just talked about, the guidance that the state's been giving throughout, would say absolutely, positively yes. That's the obligation of the team. The obligation of everybody is to figure out if a student's not able to engage and participate and learn, is to work with the family and not put it on the family to figure out how do you, I mean, it's going to take creativity of, you might need to bring in some out of, I don't know what the barriers are, but you may need to bring in some experts around your child's specific disability to help work with the team to figure out how to overcome those barriers to remote learning. It's great that they're asking for your ideas and your input, and you may have other outside a therapist or others who could also give input, but they should also be accessing the resources that are being offered by the state to help problem solve what the barriers are. Liza, other thoughts to add?
Yeah, no, I completely agree with that. I would say that ultimately it is the school district's responsibility to ensure that your child is accessing his or her education, and the school district should be partnering with you and gathering your input, definitely, especially during this time. But that doesn't mean that you should be the one responsible for figuring out how that education should happen, and figuring out how your child can access remote learning. I think the school district is still ultimately responsible, but that partnership should be strong.
Right, and there are increasing resources being offered to districts as they're trying to problem solve these kinds of things, and there are experts throughout the state in different disability types who are, again, back in March and April, I think everybody was had no idea at first how to start teaching any kids, let alone kids with significant disabilities remotely. There are some kids for whom it is going to always be very, very difficult, but there's increasing expertise and knowledge about how to begin to make things more accessible. And so the team should really work to access those kind of outside resources and supports if they need them.
Thank you. Next question. What options or rights does my son have to fight for his full services? He is nonverbal and requires one-on-one in-person services. He's only getting half of his services. Also, we've been told that having a one-on-one is not really needed at this time since when in person the classes are smaller.
Liza, you mean?
Yeah, no, I think it's a really good question. I think it's the kind of situation that probably a lot of parents are running into. So it sounds like your child is only receiving half of what's on, I think it's his IEP. So I think that's a really good example of a time to file a PRS complaint. If you've already kind of exhausted all efforts with the school district and through the IEP team process, and trying to work with them to figure out how the rest of your son's services can be delivered. And if they're still not being delivered after you've made those efforts, I think that it would be appropriate to file a PRS complaint potentially. Julia, did you want to add?
No, I was just going to say, if you as a parent are confident that your child's needs aren't being met in the alternative way they're trying to do it without the one-to-one aid, then you can certainly pursue that. If you're wondering whether it might be or not, then you could use the observation law. You absolutely have the rights, as Liza said, but the observation law is still in place. It allows you to observe what's going on in the classroom. You might have to observe remotely, but that's another way for you to get a better idea of what is going on in the classroom with this reduced class size. So you, even if you do file the complaint or pursue things first with the superintendent's office, you'll have a better idea of what's going on if you can observe how it's working in the way they're talking about.
Also, my interpretation is that if the one-to-one aid is on the student's IEP, they can't say that, because of COVID, the circumstances are different and there are fewer students, so your child doesn't need it. I think they have to.
They can't. Just whether
they still have to implement the one-to-one aid according to your child's IEP. So just to make sure that part is clear.
You're right, absolutely. But I was just saying, if the parent was, parent, you always have to decide what is the most important thing that you want to push or not. And so if you're, it's just a way to get more information either way.
Yeah, no, I think that's a great idea.
I agree.
Yeah.
I agree.
Someone's asking where they can find the resources that are available to schools for the creative ideas that were mentioned? Can parents have access to that information?
I mean, I think there's I don't want to overstate it, but there are many different professional development opportunities that the state is offering, and I know different districts are trying to work with educators and specialists that they can have access to help problem solve these issues. So if you go to DESE's website, you can see a lot of the kind of professional development opportunities that are being offered, and they're also trying to you know, as districts are problem solving the solutions in one district, share that information in other districts. So I think there's a real effort to try to provide this expertise, but I don't know of one-stop shopping area. But again, if you all are struggling with particular issues and looking for some folks who may have expertise in certain areas, that's another thing you could call our helpline about, because we could also help point you to some potential outside expertise that you could suggest to your district. And we are able to keep going till 9. We know some people have to leave now. And so Joanne's putting up the final evaluation poll.
By fast. This question is, I would like to ask what the legal ramifications are, if any, of not being allowed into my son's school to give him a needed G-tube feeding with special food just for that day, but instead having to give him the food outside one day in inclement weather. And that this child does have an extensive IEP, and the G-tube feedings are a part of the IEP. The nurse regularly gives him the G-tube feedings, but this day he needed a different food that the nurse didn't have. And this is COVID-based, as no visitors are allowed in the school at this time. So what are the legal ramifications, if any, not being allowed into her son's school?
I think we would probably need some more detailed information to give. I mean, obviously your child has to have their IEP implemented. It has to be able to get the nutrition that they required when they're in school. And it also has to be done in a way that's consistent with the health and safety requirements that are in place. But I just have more questions about the facts that make it hard to give a very clear answer, but it has. So I don't know if you have another, since I can't ask the person the questions I would have about, you know, for instance, is there a way to get the food into the building so the nurse could give the other food there? I mean, there's too many questions that I have offhand, but Liza, do you have other thoughts?
No, I had similar questions. My first question was, you know, if the IEP specifies who gives the feedings, and it sounds like the nurse usually does, but this was an exceptional situation. And so, yeah, I think I would need to understand a little bit more about, you know, whether it wasn't possible for the school to provide the feeding for some reason, or
well, it sounded like the nurse was there. I took it that the nurse was there, but the particular food that the child needed wasn't in the building.
The food, that right, exactly. But I had the same question about whether, if the parent could drop off the food for the nurse to.
I think that'd be great to contact our helpline, because we just don't have enough details to give a guess. But the bottom line is there needs to be a way to make sure your child gets what they need safely.
And that the IEP is implemented.
Thank you for your questions. We have a question from Facebook. For students who have been discharged from IEPs and are now on 504s, what, if any, portions of Section C, required accommodations, would be reasonable to expect to be implemented remotely?
That's a really good question. And the federal Department of Ed, as well as the state, has been clear that accommodations that are necessary to address a child's disability, which would include accommodations on a 504 plan, absolutely need to be provided to make remote instruction accessible. And again, if this parent is struggling getting the accommodations needed to make the remote instruction accessible, we could, if they want to email or call our helpline, we could give them some of the sites to support that. Liza, other things to add to that?
No, I agree.
This question looks like it's from an advocate. Are there any virtual assessments during an IEP testing period that are being waived from schools not having to complete? I have parents in several districts where they're asking for extensions because they don't do those assessments virtually.
So are they being waived? I think they're talking about evaluations, when students get their 3-year evaluation or their initial evaluation, as opposed to an assessment like MCAS. Is that how you interpret this
That's
question?
my understanding. That was my take too.
So if they're talking about, whether they can waive a psych eval or a speech eval or an occupational therapy evaluation, the parent has the option to waive it if it's a reevaluation. And I believe this is true, Liza, to help me. And if the parent and the team agree that it's okay to postpone it, then they can agree that they want to postpone it. It can't be waived, but it can be postponed. But the parent does not have to agree to basically extend the timelines if they think it's not going to be an appropriate way to meet their child's needs. But I don't think it can be waived, if there's a requirement to conduct the evaluation. But it can be postponed if the parent agrees that it's not going to be harmful to the child to do that. That's easier to do in a reevaluation situation than for a child who needs to enter special education potentially and is looking for their first evaluations, their initial evaluations.
I think that's right. And just to emphasize, the parent doesn't have to agree to postpone. I think there have been instances in which school districts have been kind of pressuring parents to postpone evaluations or saying they have to, but the parent does not have to agree to postpone the evaluation. But the parent might decide that that's the most appropriate thing for their child based on the circumstances. It would really depend on the situation. But the other thing I would just add is that school districts are supposed to conduct all portions of the evaluation that they can conduct remotely. So there may be, certain assessments, certain inventories that can be effectively conducted remotely, and school districts should be conducting those remotely. And then there may be some assessments that are harder to conduct remotely. Some school districts are finding ways to conduct safe in-person assessments. But if your school district is not doing that, and there is some assessment that's very hard to conduct reliably remotely, then the school district is supposed to work with the parents, communicate with you to come to a decision about whether or not to, postpone the assessment evaluation.
Exactly, great.
If your child is unable to attend both cohort days because of space, and there is an outside placement who can take the child in person for 5 days, is the district responsible to pay for that outside placement?
So I think the question is if what the school is offering is a hybrid where students are not in full time, can that be a legal basis in order to try and get the school district to pay for an out-of-district placement that is open 5 days a week? I think that it's an argument that can be made. I don't think it's a slam dunk that the district would necessarily have to do that, but I think there are some legal arguments there that could be made in terms of, what we're saying, the district needs to implement an IEP. And the parent could try to argue for that. It would really depend on the facts of the situation, I think, about how strong of an argument it could be and what the nature of the child's disability is. But I think there's some potential there. What do you think, Liza?
Yeah, I agree. The only thing I would add is that if your child has significant and complex needs or, significant complex disability, that DESE's been very clear that school districts should be offering full-time in-person services. So there could be an argument, if your child does fall into that population of students, there should be a very strong argument that the school district should be providing full-time in-person services. And if your student is one of those students and the school district is not providing that full-time in-person services, I think that potentially could be a stronger argument for an outside placement. But again, it would be, very fact specific.
Yeah. But I do think that's actually a really important point, is the state has been doing a lot, and districts have been doing a lot to move forward in offering the full-time live instruction. And it's clear that for students with those more significant disabilities, that's what's required. There's also there's not a lot of openings in out-of-district placements right now either. So there's a lot of, again, that would be something to call our helpline about. I would not say it would be an easy legal argument, but I think all legal arguments are kind of creatively having to be used right now for families when their kids are not getting the services that they need.
And just to emphasize, probably many of you are aware of this, but if a school district is offering a hybrid learning model to all students, for example, the district still has to provide, or is strongly encouraged to provide, full-time in-person services to students with significant and complex needs and preschool students who are on IEPs. So I think it can get confusing because if you have a student with a disability and the district is offering hybrid, you might think that your student is only entitled to hybrid. But if your student does fall into that definition of significant and complex needs, and you could call our helpline, we could remind you of that definition, then the school district should be taking all steps they can to offer full-time in-person services.
Right, and high needs includes students who need a high number of services every day, every week. That's based on a form that every child has with an IEP. It's also defined to include students who cannot engage in remote learning, or children who use assistive technology to communicate, children with disabilities who are homeless or in congregate care, and students with disabilities who are English learners. So the state's been really clear that all those students should be getting full-time in-person instruction as long as it can be provided safely. And it's as long as it can be provided safely, that's the issue. I think arguing for the out-of-district would be, much harder if the student is able to access remote learning on the days that they're not in person. So I think really it's going to be a very fact-specific question to answer.
Great. I think we have time for one more question. If we weren't able to get to your question today, I'll put our helpline information in the chat once again. And I've also put in the chat a link to our Facebook group to connect with other parents and advocates and share some resources there. There have been some great resources shared in our Facebook group. The last question. I was told that COVID-19 compensatory services are not one-to-one compensation of missed service hours. What is the criteria? How is it quantitatively determined?
Go ahead.
Oh,
it's a great question. It's a great question. Compensatory services before, for regular times and for COVID are not necessarily one-to-one. It doesn't mean that if you missed 435 hours of ABA services, you're automatically due to 435 hours of ABA services. Sometimes a child is, sometimes a child isn't. So what the team, and maybe Lily can drop the guidance around compensatory services. The team should first discuss whether or not the child's been able to make effective progress during the time where they weren't getting all the services, and then whether or not the child was regressing during the time they weren't being offered or able to access services. And then the team is supposed to try to come to agreement about what quantity and what type of services will be necessary to address the lack of progress or the regression. So often teams will provide a one-to-one, and sometimes the team will agree that it may not need to be exactly one-to-one. If, just like everything else in the IEP, if you believe that the team is providing too few or too infrequent services, then that's an issue that you can dispute and take on to mediation or to an appeal. But the hope is that you, working with your team and with whatever outside, pediatricians or therapists you might have, that you'll be able to come to consensus about what is the way to address your child's lack of progress. So it's not a perfectly mathematical equation to figure out what the amount and type is. Liza, anything to add?
Yeah, I was going to say the same thing. Even before COVID, compensatory services were not necessarily, sometimes could be one-to-one, but not necessarily one-to-one, making up of services. But it's more a determination of what is going to make your student whole for the services and lack of progress, the services that were missed and lack of progress made. And I think that that's the case in COVID-19 compensatory services as well. So I think as a parent, you can be, or advocate, you could be thinking about, what is going to make the student whole for those losses.
Great.
Thank you. I'm dropping another compensatory services resource in the chat now.
So thank you to everybody. I mean, we know there are long days and many things that you have to do to get through every day and every night. So thank you for joining us. We hope this has been helpful and provided some strategies and tips and guidance. Feel free to contact our helpline, and we will see you in a month. Let us know if you have any thoughts about what you'd like to hear about in the chat next month, and stay as well as possible till then.
Absolutely. Great questions, everyone. Have a good night.
Bye. Thank you.